Thank you, Edward. That was a terrific exposition of some of the critical questions that we're facing in this area, and we have a little time for questions. But I'm just going to preface that by drawing attention to a couple of other things that arise from what Edward has said. I work very extensively in the prison system at the moment, and the idea that under OPCAT, that's the Optional Protocol to the Convention Against Torture, for those who didn't get it, that the capacity of people to come into the prisons and inspect what's happening in the prisons is really important, because if people knew some of the things that are systemic in the prison environment in Australia, the idea of simply lock them up, throw away the key, people would, I think, start to get a different appreciation of how we treat people. Some people who are there for offences that we would regard as not necessarily worthy of imprisonment, traffic offences and non-payment of fines and things of that nature. And yet at a time when we're short of money for schools and roads, we're spending $8 billion over the next 20 years to build more prisons. It's also within the law. I was remarking just today, whereas on the one hand in the United States, the Supreme Court has given people under their freedom of expression protections, First Amendment, the right to say anything in terms of their religious belief, no matter how hateful or no matter how harmful. And today, the European Court of Justice handed down a decision that says that employers in the European community can prevent their employees from wearing religious identification in terms of the way in which they dress, or whether they wear a crucifix or whatever it happens to be. So this is a very fraught and contested area. I'm going to start the questions by asking Edward to address one of them in particular, and that's this. I was really impressed with your discussion about South Africa. Part of the problem in South Africa, it always seemed to me, was that a lot of the apartheid was based on the fact that the Dutch Reformed Church, in fact, specifically defended apartheid as religiously sanctioned, that there were religious principles behind the separate but equal treatment, the separate treatment. And we in Australia interfere with people's religion in terms of the fact the courts have said that Jehovah's Witness parents can't deny their children blood transfusions, we prevent polygamous marriages, we regulate halal or kosher slaughter practices so that they're humane. What is the point, in your view, at which the law can in fact start to impose upon not the belief but the expression of religious belief?
That's a terrific question and not an easy one. For me, in philosophical terms, the starting point is the harm to others principle. So the key question has to be whether what a religious organisation is trying to do is essentially regulate the behaviour of their own adherents in a way that is not going to be particularly harmful even to those adherents, or whether what that religious organisation is seeking to do is to impose strictures that may go to people's basic fundamental rights more broadly. And if it's the latter, then I'm much more likely to be wary of it.
Philosophical question to this whole debate, and that is, should I ever be tolerant of intolerance? And if, arguing that I must minimise harm to others, I am intolerant of intolerance, do I then become like the people that I don't want to tolerate, or whose views I so much disapprove of, and not only disapprove of, but would prevent the expression of because they might harm others?
Well, I feel like I have a very narrow path to tread before I end up in a kind of Donald Rumsfeldian web. The short answer is, I think, yes, we should be tolerant of intolerance in certain situations. In other words, we should be willing to stand up for free speech, including in respect of speech that many, perhaps all of the people in this room would find offensive. That is an important protection of our liberal democracy. It goes right to the heart of our liberal democracy that difficult views are able to be expressed in an open way. Partly so those difficult views, if they're wrong or if they're ill-founded, can be demolished publicly and can be shown to be as false as they inherently are. There are some limits to free speech, though. There always have been. For hundreds of years in the Anglo-Australian tradition, we've always accepted limitations on our ability to impugn the reputation of others. So defamation or libel law does exactly that. Privacy law does that as well. Whole swathes of commercial speech is protected by intellectual property. Impingements on free speech are as old as the hills. In the human rights context, perhaps the most kind of pressing current concern is in relation to sections 18C and 18D of the Racial Discrimination Act. And there the balance is a really difficult one, and I think we should acknowledge that. But the point is that when that speech is at a level that it is likely to cause significant harm to the objects of that speech, that is where the law should step in. But that should be a high bar. And frankly, I think what is not well understood is that while the words of 18C suggest a relatively low bar, the way in which the courts have interpreted Section 18C in conjunction with 18D sets a higher bar than many realise.
Other questions?
Oh, Bella, you're probably aware, and many in this room are aware, that we're very close to this New South Wales government finally introducing a law that makes criminal promoting violence or harassment of people, including on the basis of their religious affiliation. And I'm very much looking forward to the Attorney-General making the appropriate announcement very soon. But the reason I put that forward is, do you agree with some of the conservative commentators who say that only when what is being said against religion incites violence or harassment should there be any proscription of the law?
As a federal statutory office holder, I have to be very careful not to tread on the toes of the state and territory governments. But I'm well aware of that reform process that's been going on for about 5 years now. We've been consulted just to give our own experience and expertise. I think linking these sorts of offence provisions to a direct incitement of violence can make that law a dead letter. So there is a provision, a criminal provision indeed, in New South Wales law, but it has never been successfully operationalised, including in respect of some very, very shocking and terrible and damaging and harmful speech. So without expressing a specific view on that particular question, I do think that if you set the bar so high, then really what you're doing is, I guess, hoping that the law will only have an educative function, but you almost certainly will never have a situation where the law is actually able to be used in a practical sense. And maybe that's what's desirable, but I think what part of the impetus behind this reform process under Premier O'Farrell when it started was an observation that these laws hadn't been able to be used in practice, or the existing law hadn't been able to be used in practice.
Take a last question from John.
The law always exists in a social, political, cultural context.
Yep.
At the moment we're seeing, with the proliferation of new media, a drawing apart of many of the sort of cultural understandings. What I guess what I'm asking is, how does the law function in terms of a society where it seems that part of the dilemma is a decline in cultural literacy? That is part of the problem really one of general cultural literacy? And the proliferation of media is in fact amplifying that problem, hence the Trump phenomenon perhaps in the United States, rather than helping the problem.
It's a great question, and I'm at risk of giving a slightly long answer, so feel free to cut me off if I get too lengthy here, because can't give a glib answer to that. If I can come back to something that I was saying before, that there's a real limit to what the law can do, particularly in protecting and promoting people's basic rights, especially in an era as we are now where people are much more fearful than they were just a couple of years ago. So what that means is we need to be creative in working out how to, as you say, improve people's cultural literacy. And to maybe put it even more simply, we need to improve people's ability to see the other in themselves. So can I give an example of what I mean by the limits of the law? There's this wonderful US academic who talks about talks about the limits of the law in the context of how we drive on the streets. So he said, until 20, 30 years ago, we would limit the speed, we'd limit how fast people drove by putting up, speed signs, and people would know that there was a chance, a very small chance, but maybe a 1% chance that if they drove at 80 kilometres an hour in a 60 zone, that they would get caught and they'd get punished for it. Did it have a huge effect on the way in which people behaved? A bit, because as I said before, most people basically adhere to the law, whatever the law says. But on the whole, it didn't have a huge impact on compliance. And so then a different idea came in, and that was that you could change the environment to regulate people's behaviour, to internalise the lesson that you can't drive over a certain speed. And so we see that in the way in which there are now speed humps in our roads and roundabouts and so on. So if you're driving your car and you come towards a speed hump, you don't want to drive above the speed limit because you'll break your car. And no one wants that to happen. And so you'll internalise that lesson. You may or may not say, well, it's a good idea that I'm driving this slowly, but you will internalise it much, much more effectively. I guess what we need to be more creative about is helping people internalise those lessons. Yes, the law has a really important role to play, and it sets standards, and so I don't want to in any way diminish that idea. On the other hand, the things that can really have the biggest effect on people is how you go into schools and workplaces and everywhere where people gather and help them to understand another person's perspective, particularly a person's perspective that is not easy to sympathise with. And that's why I could have given any number of examples, but that's the main reason why I focused on detainees and prisoners. They're people on the whole that we don't naturally sympathise with, but it's really important that we do.
Peter, thank you very much, particularly for some of the really interesting things that came out in terms of those questions. Although I must say, in relation to speed zones, I thought you were going to say that the way in which we fix it now is to set up a whole series of secret cameras so that you get caught whether you know it or not, in which case you and Elizabeth can have a dialogue about the best way to internalise behaviour change. But I really do want to thank you very much for the provocative speech and for a very informative response to some of those really testing questions. We appreciate that very much. I'd now like to ask Peter Dukas, the Chair of the Ethnic Communities Council of New South Wales, to be good enough to make a small presentation. Thank you. Ladies and gentlemen, as you've heard on a number of occasions, Affinity is an organisation which is being founded by people in the community. It does a terrific job of bringing people together for the dialogue and for the exchange of ideas, and for the presentation of these lunchtime addresses. It relies very much on local businesses and individuals to fund many of the programs and the events, and they deserve our sincere thanks, because without their support it wouldn't be easy for Affinity to bring all of you together and to make such a positive contribution to things. Today's sponsor is Mr. Sammy Raymond, and I'd like to ask Edward whether he'd be good enough to present him with a small gift to recognise his contribution. And now it's a great pleasure to hand back over to Ahmed to draw the proceedings to a close.